This program will provide some guidance in understanding the requirements for obtaining a domestic violence injunction for protection. Violence and abuse are crimes. To become a survivor of violence and ongoing abuse, you should seek help from law enforcement, the court system, and community resources. The Pinellas County Clerk of Court's office created this guide to provide answers about injunctions for protection or restraining orders and how to apply for them. We encourage every victim of violence to first contact law enforcement. We are here to help you. An injunction for protection is a civil court order that places restrictions on an individual referred to as the respondent, who has allegedly committed acts of violence or made threats of violence against another individual referred to as the petitioner. Violence is defined by Florida statute as any assault, aggravated assault, battery, aggravated battery, sexual assault, sexual battery, stalking, aggravated stalking, kidnapping, false imprisonment, or any criminal offense resulting in physical injury or death by a person against another person. Violence does not include all offensive or threatening behavior. Trespassing, criminal mischief, threats, tampering with a witness, and harassing phone calls are all criminal offenses which should be reported to law enforcement, but may not by themselves qualify for the issuance of an injunction for protection. An injunction should not be used as a tool to manipulate the respondent or the judicial system, gain access to property, or to settle issues of child custody or spousal support, but rather to protect you against a genuine and well-founded fear of violence or abuse. An injunction may include provisions that prohibit the respondent from coming within 500 feet of your residence, place of employment, school, or any other non-public place you must go to often. Prohibit the respondent from coming within 100 feet of your vehicle. Order the respondent to leave a shared dwelling. Award temporary custody of minor children you have in common. Prohibit the respondent from possessing, buying, or using firearms. Order the respondent to complete a batterer's intervention program. Florida law separates injunctions for protection into 5 categories: domestic, repeat, dating, sexual, and stalking. When determining the type of injunction you need to file, it is very important that you listen to all of the requirements for each type of injunction before selecting one, because choosing the incorrect type may cause your petition for injunction to be denied by the judge. Domestic violence is violence or stalking that has occurred or that you have reasonable cause to believe is going to occur by a person who is or was a spouse, a person you are related to by blood or marriage who you have resided with as a family, or by someone you have a child with. Repeat violence, which is usually appropriate for neighbor against neighbor, co-worker against co-worker, or other types of relationships that are of a non-domestic or non-dating nature, and is defined as 2 acts of violence or stalking by an individual against yourself, one of which must have occurred within the past 6 months. Sexual violence is an incident of sexual battery, a lewd or lascivious act committed upon or in the presence of a person younger than 16, luring or enticing a child, sexual performance by a child, or any other forcible felony wherein a sexual act is committed or attempted. For an injunction for protection against sexual violence to be granted, one of the following criteria must be met. 1. You must have reported the incident to law enforcement and be cooperating in any criminal proceedings. Or 2. The respondent must have been sentenced to prison and the term expired or is due to expire within 90 days. Dating violence is violence or stalking that has occurred or that you have reasonable cause to believe is going to occur by a person you have been in a dating relationship with on a continuous basis within the past 6 months, and that you have had an expectation of affection or sexual involvement from. Stalking violence is when one of the following occurs:
2 acts of stalking on 2 separate occasions, one of which must have been within the past 6 months by an individual against you. A person who willfully, maliciously, and repeatedly follows or harassed another person commits the offense of stalking. Harassing behaviors may include vandalism, annoying or threatening phone calls, following or other violations of protective orders, sending unwanted letters, cards, or electronic mail, or other electronic communication, leaving you gifts, showing up at your workplace, home, or school, or attempting to obtain information about you from others, causing substantial emotional distress and serving no legitimate purpose.
If you are a minor and are seeking an injunction for protection, one of your parents or your legal guardian must file the petition on your behalf. If you are filing a petition for injunction against a minor, you must provide the clerk's office with the full name of the minor child against whom you are filing, as well as the full name of that minor's parent or legal guardian. A petition for injunction for protection may be filed in the county where you currently or temporarily reside, where the respondent resides, or where the violence occurred. There is no residency requirement, nor any filing cost.
A petition for injunction for protection, commonly called a restraining order, can be filed in Pinellas County by filling out and printing the forms available on the clerk's website or at the clerk's office. There are 2 simple ways to access the forms from the clerk's website by visiting www.mypinellasclerk.org. From the home page, click on Forms and Packets. From the list, click on the category Domestic Violence, Injunctions for Protection. There, you will be able to access the forms you need to file your injunction request. Make sure to read the injunction filing checklist located before the list of forms. This checklist will assist you in choosing the correct forms for your specific injunction type. Another way to access forms from the clerk's homepage is to hover your mouse cursor over Find a Service on the top menu bar. Then, click on Domestic Violence and Restraining Orders from the drop-down list. Next, click the tab labeled Injunction for Protection Forms. The injunction filing checklist is also provided here so you can easily identify the forms needed for each injunction type. Once you have filled out and printed the forms, they may be filed at one of 3 Pinellas County Clerk of Court locations between the hours of 8:30 a.m. and 4:30 p.m., excluding weekends and county holidays.
If you feel you are in imminent danger of violence, you may file for an injunction for protection by contacting local law enforcement 24 hours a day. The 3 Clerk of the Court locations are the Civil Court Records Department, located in downtown Clearwater at the Pinellas County New Courthouse, 315 Court Street, room 170, Clearwater, Florida, 33756, 727-464-7000.
The Criminal Court Customer Service Department, located in East Clearwater at the Pinellas County Justice Center on 49th Street between the Bayside Bridge and Almerton Road,
14250 49th Street North, 2nd floor, Clearwater, Florida, 33762, 727-464-7000. Or the St. Petersburg Branch Office, located in the St. Petersburg Judicial Building at Mirror Lake on 1st Avenue North, 545 1st Avenue North, room 101, St. Petersburg, Florida, 33701, 727-464-7000. A deputy clerk will be available to answer any questions that are not construed as legal advice when you come in to file. Please remember that this office cannot provide legal advice. Only an attorney can legally assist you with legal advice. Once you file your petition, a deputy clerk will take it to a judge to be reviewed. The judge may make one of three decisions. If the judge feels that your petition meets the law's requirements and that you need protection, an ex parte temporary injunction for protection will be entered for you. Sheriff's Service will notify the respondent. You will be ordered to appear at a hearing within 7 to 15 days with the respondent. At the hearing, the judge will determine whether or not you need further protection. The term ex parte means that the judge has only considered the testimony of one side, you, the petitioner. This is why you are required to appear with the respondent before the judge. If the judge does not feel that your petition merits the issuance of an ex parte temporary injunction for protection, but wants to hear further testimony from you, he or she may order you to appear at a hearing with the respondent, who will be notified by Sheriff's Service without issuing a temporary injunction for protection. If the judge does not feel that your petition meets the law's requirements and that further testimony would not be beneficial, he or she may deny your petition completely, in which case no further action will be taken.
The respondent will not be notified if a petition is denied. All information contained in a petition for injunction against domestic violence, repeat violence, dating violence, sexual violence, stalking, or cyberstalking will be confidential and sealed from public view until the respondent has been served, the case is dismissed, or the petition for injunction is denied. For sexual violence cases, the petitioner's name and identifying information will always be protected from public view. You will have the option to be notified of the judge's decision via email, or you will need to return to the clerk's office where you filed your petition prior to the end of the business day to find out which decision the judge has made. However, you still must return to one of the clerk's office locations with photo ID to receive the certified copies of the court order. No one else can pick up these documents for you.
It is extremely important to have a copy of the court order if your injunction is granted to ensure immediate protection. Be sure and collect all your paperwork before you leave the courtroom. It may be necessary to provide a copy of the court order to law enforcement in the event of a violation. There are 2 domestic violence centers in Pinellas County that provide assistance with filling out forms, Spanish translation, emergency housing, counseling, children's programs, transportation, and other services. These centers are CASA, located in St. Petersburg, and can be contacted at 727-895-4912, and the Haven of Religious Community Services, located in Clearwater, at 727-442-4128. There are also 2 legal self-help centers available to serve you in Pinellas County. Self-help centers offer assistance with filing forms, a notary service, and appointments with an attorney for only $1 a minute.
There are 3 centers to serve you. The Clearwater Self-Help Center, open Monday through Friday from 8:30 a.m. until 4:30 p.m., located in the new courthouse in downtown Clearwater. Call 727-464-5150. The St. Petersburg Self-Help Center, open Monday through Friday, 8:30 a.m. until 4:30 p.m., located in the St. Petersburg Judicial Building in downtown St. Petersburg. Call 727-582-7941. And the North County Branch Self-Help Center, open Tuesdays only from 8:30 a.m. until 4:30 p.m., located in North Clearwater, 29582 US 19 North. Call 727-464-5150.
If you have any questions regarding this video, the terms used in it, or the filing process, please take time to review our website at
mypinellasclerk.org or contact the Civil Court Records Department at 727 464-7000 between the hours of 8:30 a.m. and 4:30 p.m., excluding weekends and county holidays.
We encourage every victim of violence to first contact law enforcement. We are here to help you.